Probably.
Okay, does anybody listen to me?
Right from the start, the judge sounds frustrated, and that's a red flag. When a hearing opens like this, it usually means things are already off track. The real question is, who's about to lose control first?
Lori Anderson versus Armani Lyman. Bueno. And that's it. State your names, please.
You're going to be okay.
State your name. All right. I reviewed everything in the file, and just to try to resolve the matter if we can. Set it for a final settlement conference today to see if there's a resolution. Ms. Lyman?
Yes.
Do you still wish to reside in the property?
Yes. Last court date, she asked me to stay, and I decided that I would.
Pardon?
Last court date, she talked to me after court, asked me to stay, so I decided that I will stay.
Okay. And Ms. Anderson, where are you on this case?
I want to apologize for talking.
Pardon?
I want to apologize to you for over talking.
It happens. All right.
I just hesitate because I'm worried about the condition of the property. From the outside, there's already damage, and Ms. Lyman has approximately $20,000 of damage on a prior property on Maplehurst. Mr. Fink told me about. So, I mean, I have a $500,000 property, and I'm worried about it coming down with Ms. Lyman, since she has a prior history of damaging property.
Go ahead, Ms. Lyman.
Honestly, I feel like the little Fink situation on June 27th, he had contacted her.
I don't know what that means.
So I feel like that's a conflict of interest, and we're here for 4259 Court, not Maplehurst. So I don't see why that's being brought up, and for that was a small situation.
Hold on a second. I don't know anything about that. So that's not under my head. Let me ask you this. Has rent been paid and everything, or?
No, I have not.
This escrow part is critical. The court is basically saying, pay your rent, prove you're serious, or risk losing everything. It's not a suggestion, it's a test. Miss this step, and the case can flip instantly.
All right.
She said she would put the $3,300 in escrow.
All right. Is that what you would do, ma'am?
Yes, I did say that, but our last court date, you said that $25 a day was excessive. I ended up paying that $25 a day last month, so I was asking if I could pay
$25 a day?
Yes, so I was asking, could I pay $3,000?
Well, there's gonna have to be a claim on that, but what's the monthly rent?
$3,000.
All right. So I won't give a discount on that. We'll figure it out, but you've agreed to put that into escrow? The $3,300? Put it to place $3,300 in escrow, and that's really for the month of July, correct? And then $3,300 per month thereafter. All right, folks, just in terms of resolving, go ahead.
What I was about to say, because last month I ended up paying the $25 a day, so I ended up paying.
I hear you. You're about to repeat yourself. I will resolve that once we get to the end of everything.
Okay.
If it is indeed illegal, but I'll figure it out. Yes, ma'am.
Last time you said that I could get $100 for late fees for June.
I'm not going to deal with late fees, folks. All right, right now. I'm just not. I mean, the issue is that if there's gonna be an agreement that she'll stay, because you filed a termination case, we have to figure out what the terms of that will be. Yes,
I really don't want her to stay because I'm worried about damages to the property.
okay, so didn't we just go through this? You guys had a conversation about her stay, right? There then becomes this issue regarding damages at other I don't know anything about that. You're worried about damages at the premises. So what I was gonna suggest to the parties is this. Would you object, because actually I can order it in any event, but that she's permitted to do an inspection of the premises?
There's no damages to the property.
Okay. Yes,
From the outside, there are already 3 damages. There's oil stains in the driveway. There's blinds and the blinds in the back have been damaged. The screen in the back has been damaged. So that's just what I can see on the outside damages, and that's probably.
okay, does anybody listen to me? Because it would seem to me that the way to resolve this issue would be for you to be permitted to do an inspection of the premises. Yes,
Also, she would need to change the locks back because I didn't authorize her to change the locks.
what does that have to do with anything right now? Yeah,
I don't want to offend you.
what?
I'm trying not to offend you, so I don't want to.
I'm not easily offended, so go ahead.
I just, if she wanted to work something out, I would have to be able to talk to her and not the older woman. I mean, there has to be some communication between me and her and not me and this older woman. And she would have to abide by the terms of the lease. That's all I'm asking, sir. I would work things out.
Yes.
She keeps talking about an older woman when.
Okay, so first of all, stop, both of you. I don't know,
And here it is, the real issue exposed. Not money, not damage, communication. They keep talking, but no one's actually listening. Be honest, could all of this have been avoided with one proper conversation?
come so close and then you guys just start talking past each other about stuff that may in the end not mean a thing. So the first thing is, if her tenancy is going to be maintained, you got to get the 3,300 into escrow. You want to do an inspection of the premises. What date are you going to do the inspection? What date would you like to do the inspection?
This week,
All right, would you be available to let her in to do the inspection this week?
No, I have school and work for the rest of the week. Mandatory school. Could we try for like next week?
Monday, next week. What's wrong with that day?
What time?
in the afternoon, Monday would work. I was just asking a question.
What's the question?
Did you, ask her to change the locks back?
No, she's gonna be there. I'm not gonna deal with that right now. Okay? What I'm gonna do is there's gonna be an inspection on the premises. So there'll be an inspection on the premises on the 21st. 2025 at, will 2 p.m. work for you? Yes? 2 p.m. All right. Then I need you guys back on, I'm going to move this to, when's my hotspots block on the first?
3 p.m. here.
So then I want to see you guys August 1st, 2025 at 3 p.m. That'll be an in-person hearing. Back, we'll look at what the inspection is and how we can go forth with this tenancy.
If the rent is in escrow, how do I pay the mortgage with the rent in escrow?
Well, it's going to be an escrow. I'm not clear, ma'am. It's going to be placed in escrow at this point in time, and then we'll figure out what we do on the 1st. Okay? Anything else from either side? I'm almost afraid to ask.
Just, can I be able to call her on her phone and talk to her?
I don't know. Are you capable?
Yes, I.
Okay. Will that work for you?
Yes.
And you'll answer? Okay. That's resolved. Anything else? Great. We'll see you on the 1st. Thanks, folks.
Pouring kerosene with them still inside and their baby.
Case of the people versus Mary Barney.
Is that not what we have?
Assistant Public Defender Chelsea Virgil, on behalf of Mary Barney. Please state your name. Mary Barney. I turned in a green sheet regarding the PCC. We're asking to adjourn that.
Okay. And as to your motion.
As stated in the motion, I'm asking for release to inpatient treatment. I think that for Miss Barney, it's kind of a monumental time for her. It has taken her a very long time to come to terms with admitting that she has a substance abuse issue and admitting that contributed greatly to her criminal history. She wants to get treatment. She wants to do better and be more stable for her kids. And she's already actually starting an initiative on that. She's doing AA at the jail. She's on the wait list for Dawn Farm. And, you know, all around trying to improve herself. We have no objection to a scram tether or a GPS tether if she is released to treatment. She just really wants that intensive opportunity to better herself.
Response.
Your Honor, at this time I'm going to strongly object. Her criminal history includes pretty much only assault of crime. She has an aggravated assault from 2023, a child abuse, fourth from 2024, an assault with one of the same victims in the current case, I believe from 2024 as well. And in this case, she is exhibiting a clear escalation in violence where she is at the residence, setting their car on fire on camera, on their wooden porch, pouring kerosene with them still inside and their baby. I mean, it's egregious. And I have concerns that she is a serious danger to those people and she could have, if not caught before she set the fire on the house, could have killed people. And I mean, I get that it's a big step for her to take accountability for her issues, but I also think that she can start that treatment in custody doing Dawn Farms and AA, and I have concerns that if she were to get out to inpatient, if she were to leave inpatient, what that would mean for the community. She's obviously ramping up her violence towards other people, and I have concerns. She also, I did mention, there was another warrant that we did review and did charge her. I don't believe she's been arraigned. It was done this week. She now has another case with 4 counts of child abuse, 4th degree second notice, which are felonies. In relation to this case.
So, hold it, there's another case coming?
Yes, there's another case coming that is related to this case where she left the children to go commit this crime and was charged for that action. I have concerns that she's been given numerous opportunities with her probation to change her behavior, doesn't do it, violates probation, and then comes back here with the more serious, more egregious felonies. I just have significant concerns for the community. She was unable to follow a PPO. That one of the victims in this case has a valid PPO against her. That didn't stop her from going to the residence and setting fire to the car and potentially to the house. So I mean, I think she's a significant risk to the community, to the victims. She cannot follow court orders, as she has shown by violating a PPO and violating previous probation. So I think at this point, the safest place for the community and for Ms. Barney is for her to remain in custody. I have concerns that if she were to get out to inpatient and just leave, even with a tether, I don't know what she would do at this point. So I don't think it's appropriate for her to be released to treatment at this point.
Anything else?
I did become aware earlier that there are new charges, but there are not new facts. That is from the same incident. The same facts that we have all been aware of the whole time are, she maintains that those are just allegations at this time, and that alcohol was a contributing factor. I think that this time is very different for her, that in the past when she had these incidences that she was in denial that alcohol was contributing, she did not have the commitment that she has now to change the trajectory of her life. And I think that all the efforts that she's engaging in at the jail show that she wants to be in this treatment. I don't think that she would leave the treatment, and I believe that the tether would be adequate if she were to leave, which I don't think that there are any circumstances which she would. You could go get her immediately.
Given all the circumstances, well, let me say this first, and I don't know if council's aware. Bernie was received by the court on December 9th, a 3-page letter.
I have not seen it.
You have not?
No.
And I'm presuming you haven't. Okay, the court will provide the parties a copy of that. However, given all of the circumstances of this, the underlying case, and now there's a new case, I understand that it may fall from these incidents, but new charges coming as against this defendant. The court is going to deny any request for modification of bond in any fashion whatsoever. Let's take a look at the letter, because there are certain things within this letter that may or may not cause some concern. And so what I will do is deny a request. Bond will continue in its current. All right, and I will set this for December 23rd, 2025 at 9 a.m. All right. Thank you.
Subscribe now and comment below. Was the judge's decision fair?